Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University School of Law, SOL. Postgraduate Diploma in Intellectual Property Rights, Pgdipr. MIP106 Plant Varieties Protection, Biotechnology and Traditional Knowledge. Block 1 International Conventions for the Protection of New Plant Varieties. Unit 3 Obligations under other international instruments on plant genetic resources. 3.1 Introduction. Genetic resources have played a significant role in the development of humankind by providing food, feed and fodder, and also numerous medicines and industrial products. We have studied in Unit 1 that plant breeding is a process by which genes are recombined either through selection, crossing or other modern breeding techniques using genetic resources. The full spectrum of plant genetic resources of any crop consists of diverse type of collections such as those derived from centers of diversity, those derived from centers of cultivation and those derived from breeding programs. Some of the valuable genes found in PGRs have provided tremendous boost to the crop improvement programs. Emphasis on new breeding objectives, such as increased stress tolerance, biological efficiency with reduced inputs, mitigation of effects of climate change, etc., also are necessitating plant breeders to look once again at genetic resources for new sources of genes regulating the various desirable traits. The recent advancements in new technologies, particularly biotechnology, including molecular biology and genetic engineering, metabolic engineering, have profoundly expanded the pool of genes potentially available for the breeding of new crop varieties, thereby increasing the value of the genetic resources. By and large, the tropical and subtropical regions of the world, mainly comprising the developing nations, are endowed with rich plant genetic diversity. However, all the countries are interdependent on their germplasm needs, and no country can claim to be self-dependent for present or future on germplasm needs. During the period from 1980s, the economically advanced countries were not only developing capacity for deploying novel methods and techniques in genetic manipulation, biotechnology, but were also equipping themselves with legal instruments by unprecedented enhancement in the level, scope, territorial extent, and role of intellectual property rights, LPR, that were now applicable to plants and plant products. The creation of new knowledge utilizing living materials was, therefore, perceived as a means of generating commercial goods by converting them into useful value-added products, production process and services. This attracted large multinational corporations to undertake life science research, which was earlier largely a prerogative of the public sector institutions. The developing countries were, therefore, legitimately concerned that the transnational corporations would take a short-term, opportunistic view of genetic resources conservation and exploit it for monopolizing the control and use of biologically derived materials, specifically through product or process patents or plant breeders' rights. The opportunity to transform the genetic resources from public to private goods would also lead to restricted exchange of genetic material, especially proprietary material, with public and private plant breeders. These developments made conservation and use of crop germplasm highly politicized in recent years. Debates at national and global forum that cut across wide range of sectors, such as food and nutritional security, biological diversity, conservation and environment degradation, economic, social and cultural development and ethics and human rights. Although the anthropocentric view of conservation of biodiversity was supposed to have encouraged the utilization of such resources for the benefit of humankind, the emerging IPR regimes and their intricate relationship seems to have had a contradictory effect. The world opinion today is clearly divided into two groups, one favoring a strictly regulated control of genetic resources and other advocating flexibility and limited control in access. the complexities have largely emanated from two global developments, namely, the Convention on Biological Diversity, CBD, and the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, administered by the World Trade Organization. These two developments have led to new dimensions of statutory provisions and regulatory obligations that make access and utilization of genetic resources not as unrestricted as it used to be. In the earlier unit we had studied the obligations under the TRIPS agreement related to genetic resources. In this unit we would examine the obligations under the CBD. The focus shall be on the provisions of CBD specific to the biodiversity-related aspects of the global IPR regime. 3.2 Objectives. After completing the study of this unit, you should be able to acquire a basic understanding of international concerns for conservation and utilization of genetic resources. Acquire a basic understanding the provisions of Convention of Biological Diversity, ITGRFK, Nagoya Protocol and Cartagena Protocol and analyze their implications on access and utilization of genetic resources, and explain the obligatory requirements pertaining to access and utilization of genetic resources as per the Biological Diversity Act, 2002. 3.3 Background of CBD negotiations. 3.3.1 Issues related to conservation. The tremendous value of the biological resources for the present and future generations. Threat to species and ecosystems has been a global concern in the last 4 decades. The first attempts were made to promote the development of an international Convention-M biological diversity when United Nations Environmental Programme, UNEP, convened an ad hoc working group of experts on biological diversity in 1988, later known as the Intergovernmental Negotiating Committee, to explore the need for an international convention on biological diversity. In 1989, it established an ad hoc working group of technical and legal experts to prepare an international legal instrument for the conservation and sustainable use of biological diversity. The experts were to take into account the need to share costs and benefits between developed and developing countries, as well as ways and means to support innovation by local people. By February 1991, the ad hoc working group had become known as the Intergovernmental Negotiating Committee. Its work culminated on 22 May 1992 with the Nairobi Conference for the adoption of the agreed text of the Convention on Biological Diversity. 3.3.2 Issues related to patents. As we have studied in the earlier unit, this period also witnessed implementation of expanded and reinforced IPR regimes applicable to life_forms in the developing countries. Compounding the problem was the fact that the patenting standards in some countries were either too relaxed or low, allowing protection for inventions involving biological resources which amounted to little more than discoveries. Patents had been granted for inventions that were either not novel or are not inventive if the traditional knowledge already in the public domain is taken into consideration. A case in example is the US patent on use of turmeric in wound healing, granted in 1995, which proved to be a landmark case of reappropriation of traditional knowledge. While the use of turmeric for healing wounds and rashes had been practiced for thousands of years in traditional medical systems in India, it was for the first time that a patent was successfully challenged by providing documentary evidence including an ancient Sanskrit text and a paper published in 1953 in the Journal of the Indian Medical Association, subsequently admitting their inability to refer to the existing prior art not accessible through digitized databases while examining novelty of an invention. The USPTO suggested access to a digital database of traditional knowledge to ensure that no patent was issued on the same. This led to the initiative in the form of Traditional Knowledge Digital Library, TKDL, in India to transcribe available traditional knowledge in books on Ayurveda, Unani, Siddha and Yoga, and document the same in electronic form. The information has been classified as per international patent classification systems, and agreements have been entered with leading international patent offices to give patent examiners access to the TKDL database for patent search and examinations purposes. Another issue related to granting of patents in the developed countries was that patents sometimes contained claims which appeared to be excessively broad. A good example is the European patent EP301749 granted in 1994 to the company Agrocetus for particle-mediated transformation of soybean plants and lines. It was one of the first patents in Europe which covered genetically engineered plants. It covered plants treated with a gene gun, a device that used an electronic accelerator to fire DNA-coated microprojectiles, e.g. gold particles, into living cells to introduce new genes into these cells. Despite the scarce evidence for the technical feasibility of the procedure, Agrocetus received an incredibly broad patent. Not only was the procedure for genetic modification patented, but also the application of this procedure to all kinds of plants. Even the seeds themselves were patented. It was challenged by the NGOs, No Patents on Life, and etc. group, formerly RAFI. They were joined by agrochemical and seed industry giants who argued from the point of view of their own economical interests. These multinational corporations included Sandoz, Ciba Geigy, Monsanto, Diploma, Pioneer Hybrid. In a hearing of the oppositions against the patent in 2003 at the European Patent Office, EPO, the oppositions were rejected, but some details in the patent had to be changed. However, in a public hearing at the Board of Appeal at the European Patent Office in May 2007, the patent was finally revoked. Reasons were that parts of the patent were not really new and other details were not described in underscore a way that the invention could be really repeated by other experts. The case study of this patent also reflects the development of international agrochemical and seed companies and the effects of their consolidation on access to technology. In this period, Pioneer, the biggest seed company in the world, has been taken over by DuPont. Ciba Geigy and Sandoz merged to become Novartis, whose seed division then separated under the name of Syngenta. Monsanto, on the other hand, bought the companies Diploma and Agrocetus and consequently was also able to acquire Agrocetus' incredibly broad patent, thus making sure it would not be in danger of economic dependence through the patent. Ironically, Monsanto, that initially opposed the patent, later defended the same patent against other companies. This confirmed the apprehensions, not only of the civil society and public sector organizations but also other new biotechnology firms as well as seed companies, that patent may lead to monopoly positions for companies or nations, thereby adversely affecting research and development in agriculture. 3.3.3 Objectives of the Convention on Biological Diversity. The Convention on Biological Diversity, CBD, was negotiated following unprecedented debates among the developed and developing countries on issues that included inter alia the questions of access to genetic resources, sharing of benefits accrued from their use, technology transfer and biosafety. The CBD was signed by 150 countries at the United Nations Conference on Environment and Development in 1992 in Rio de Janeiro, the Earth Summit, and entered into force on 29 December 1993. There are currently 191 parties, and the treaty has been ratified by 168 countries. Notable exceptions include the USA. The CBD for the first time affirmed the sovereign rights of nations over their biological resources and to exploit their own resources pursuant to their environmental policies. It has three main objectives. Conservation of biological diversity. 2. the sustainable use of its components, and 3. Fair and equitable sharing of the benefits arising from the use of genetic resources, including by appropriate access to genetic resources and by appropriate transfer of relevant technologies. 3.3.4 CBD and issue of access and benefit sharing. Implementation of the objectives of the CBD relies on the protection and use of knowledge, including knowledge of genetic material, knowledge of technology, or the knowledge of indigenous and local communities regarding biological diversity. Since most of the developing countries were rich in genetic resources, it was argued that they did not necessarily benefit equally from industrial, medical, agricultural, and other uses of genetic resources that take place with technologically advanced developed countries, which were equipped or were equipping themselves with legal instruments that expanded and reinforced the implementation of IPR regimes to life forms. Thus, the commitment of the parties to fair and equitable sharing of the benefits arising out of the utilization of genetic resources was incorporated in the CBD objectives. There are a range of articles incorporated in the treaty that reflect the concern of parties on the issues of access to genetic resources, access to and transfer of technology, handling of biotechnology and distribution of its benefits, Box 1. It can be seen from these provisions that CBD reflects not only the commitment of global community for conservation and sustainable use of biodiversity, but also makes the facilitated access to genetic resources by developing countries a two-way process by effectively linking it with equitable sharing of benefits. Technology flows are also founded on the principle of equity, with the developing countries providing resources and developed countries sharing and transferring technologies, including biotechnologies, and providing financial resources to help developing countries meet their commitments and realize benefits. The CBD incorporates two obligations in this regard, namely, for providing access on mutually agreed terms, MAT, and prior informed consent, PLC. 3.3.5 Mutually agreed terms and material transfer agreements. The concept of MAT establishes a new participatory relationship among country of origin, provider and user of genetic resources. It is a contractual arrangement executed on a bilateral basis that provides an opportunity for the providing country to negotiate a share of the benefits derived from the use of the genetic resources. It also provides an opportunity to the provider of the genetic resource to specify the permitted or prohibited uses of the genetic resources provided, including whether or not any IPR rights which may or may not be taken over the resource or its derivatives may be commercialized, and benefits that are to be shared. It is increasingly becoming common to transfer the genetic resources accompanied by a material transfer agreement, MTA. Such a document forms a contractual relationship between the provider and the recipient. It is common for MTA agreements to attach terms and conditions regarding both the approved use of genetic resources and the rights to ownership of such materials or their derivatives. MTA agreements can appear in a number of forms. While the most common is a conventional sheet of paper, it is also possible for the material to come with language included on the bag. The use of so-called backtag language is becoming increasingly common. At issue, however, is whether the shipper who applies the MTA language actually owns title to the materials and has the right to allocate ownership rights. 3.3.6 Prior informed consent. The PLC empowers the provider of genetic resource to establish an authority that can grant or refuse access following a request from the applicant as per the national legislation. The applicant is required to provide information concerning the genetic resources required, purpose for which required, and any proposal for benefit sharing for the providing party, giving it an opportunity to become an equal partner and monitoring the use As part of the PLC procedure, the authority may consult indigenous and local communities or other stakeholders concerned before granting the access. Box 1. Important provisions under CBD related to conservation, access and benefit sharing. General measures, Article 6. Times develop national strategies, plans or programs for conservation and sustainable use of biological diversity. Integrate, as far as possible and as appropriate, the conservation and sustainable use of biological diversity into relevant sectoral or cross-sectoral plans, programs and policies. Conservation of biological diversity, Articles 8 and 9. Times establish a system of protected areas or areas where special measures need to be taken to conserve biological diversity. Times develop guidelines for the selection, establishment and management of protected areas. Times promote the protection of ecosystems, natural habitats and the maintenance of viable populations of species in natural surroundings. Times rehabilitate and restore degraded ecosystems and promote the recovery of threatened species. Times regulate, manage or control the risks associated with the use and release of living modified organisms resulting from biotechnology. Times prevent the introduction of, control or eradicate those alien species which threaten ecosystems, habitat tilde s or species dash. Times respect, preserve and maintain knowledge, innovations and practices of indigenous and local communities and with the approval and involvement promote their wider application and encourage the equitable sharing of the benefits arising from the utilization of such knowledge, innovations, and practices. Times cooperate in providing financial and other support for in situ and ex situ conservation, particularly to developing countries. Times adopt measures for the ex situ conservation of components of biological diversity. Times establish and maintain facilities for ex situ conservation of and research on plants, animals and microorganisms. Times adopt measures for the recovery and rehabilitation of threatened species and for their reintroduction into their natural habitats. Times regulate and manage collection of biological resources so as not to threaten ecosystems and in situ populations of species. Access and benefit sharing, Article 15. Times authority to determine access to genetic resources rests with the national governments and is subject to national legislation. Times create conditions to facilitate access for environmentally sound uses. Times access subject to prior informed consent of resource provider and on mutually agreed terms. Times endeavor to develop and carry out scientific research based in genetic resources provided by other contracting parties with full participation of, and where possible in, such contracting parties. Take legislative, administrative or policy measures, as appropriate, with the aim of sharing in a fair and equitable way the results of research and developments and the benefits arising from the commercial or other utilization of genetic resources. Access to and transfer of technology, Article 16. Times endeavor to develop and carry out scientific research based on genetic resources provided by other contracting parties with the full participation of, and where possible in, such contracting parties. Access to and transfer of technology using genetic resources to countries providing the genetic resources. Times take legislative, administrative or policy measures, as appropriate, with the aim that countries which provide genetic resources are provided access to and transfer of technology on mutually agreed terms. Times ensure that IPRs are supportive of and do not run counter to the implementation of the Convention objectives. 3.3.7 Implementation of access and benefit sharing provisions. Implementation of the CBD is a dynamic process, and the Conference of the Parties, COP, is the governing body of the Convention that takes decisions on outstanding issues at its periodic meetings. In order to facilitate better implementation of the CBD obligations with respect to access and benefit sharing, parties have undertaken several initiatives. The CBD constituted two ad hoc, open-ended working groups, one on traditional knowledge, COP 49 1998, and other on access and benefit sharing, ABS, issues, COP V61-2000, and one panel of experts on ABS, CBD CQP 48, 1998, with representation from diverse interest groups. The terms of references of these working groups and expert panel included mainly the development of a framework that would help assist parties to develop national and regional regulations or guidelines on ABS, with special focus on evolving standards and principal elements of PLC, MAT, material transfer agreements, MTA, and monetary and non-monetary benefit sharing agreements. One of the important outcomes of 6th meeting of the Conference of Parties, held in April 2002, COP 61-41-2002, in The Hague was adoption of the Bonn Guidelines on Access to Genetic Resources and Fair and Equitable Sharing of the benefits arising out of their utilization. A. The Bonn Guidelines. The Bonn Guidelines can be construed as the first affirmative step in operationalizing the relevant CBD provisions with respect to ABS. These guidelines are voluntary in nature and indicate procedures intended to provide the parties and stakeholders with a transparent framework to facilitate access to genetic resources through the practices and procedures of PLC of the country of origin as well as MAT, MTA, and other relevant agreements. The guidelines assist in establishing and developing national access and benefit sharing regimes, while promoting capacity building, transfer of technology, and the provision of financial resources. They also seek to promote sustainable use of genetic resources by promising to improve users, commercial and non-commercial, access to valuable genetic resources in return for sharing the benefits with the countries of origin and with local and indigenous communities. B. International Regime on Access and Benefit Sharing. The World Summit on Sustainable Development held at Johannesburg, 3 September 2002, invited parties to take appropriate steps to negotiate within the framework of the Convention on Biological Diversity (RCBD), bearing in mind the Bonn Guidelines, an international regime to promote and safeguard the fair and equitable sharing of benefits arising out of the utilization of genetic resources. Following it, the Convention's Conference of the Parties at its 7th meeting in 2004, COP 7/191-2004, mandated its ad hoc open-ended working group on ABS to elaborate and negotiate, together with the working group on Article 80, an international regime on access to genetic resources and benefit sharing, in order to effectively implement Article 15 and Article 8(j) of the CBD. Subsequently, discussions were held by the working group in the 5th and 6th meetings held in Montreal, Canada, 8-12 October 2007, and in Geneva, Switzerland, 21-25 January 2008, respectively. Thereafter, recommendations on international regime on ABS were consolidated in Cali, Colombia by COP 9, COP IXLI 21-008. After 6 years of negotiations, the Nagoya Protocol on Access to Genetic Resources and the Fair and Equitable Sharing of Benefits Arising from Their Utilization to the Convention on Biological Diversity was adopted at the 10th meeting of the Conference of the Parties on 29 October 2010 in Nagoya, Japan. The Nagoya Protocol opened for signature by parties to the Convention from 2 February 2011 until 1 February 2012 at the United Nations headquarters in New York. The protocol now has 61 signatories, but will enter into force 90 days after 50 countries, who are parties to CBD, ratify the text. The objective of the Nagoya Protocol is to promote sharing of the benefits arising from utilization of genetic resources in a fair and equitable way, including by appropriate access to genetic resources and by appropriate transfer of relevant technologies, taking into account all rights over those resources, and to technologies, and by appropriate funding, thereby contributing to the conservation of biological diversity and the sustainable use of its components. The protocol envisages the setting up of an international regime on access and benefit sharing of genetic resources, which will lay down the basic ground rules on how nations shall cooperate in obtaining genetic resources and sharing the benefits arising from their utilization. 3.4 Plant genetic resources for food and agriculture. The CBD provisions encompass all biological resources, however, the plant genetic resources for food and agriculture, PGRFA, received special attention during the negotiations. 3.4.1 International Undertaking on Plant Genetic Resources. The first international and intergovernmental discussions on access to PGRFA were initiated in 1983 while negotiating the implementation of the International Undertaking on Plant Genetic Resources, IGNOU, at the Food and Agriculture Organization, FAO. It established the principle of plant genetic resources as the common heritage of mankind, and consequently these resources were available without restriction. The undertaking also raised apprehensions and issues for debate, while the multinational corporations and the developed countries raised the concern of IPR for the plant breeders. The developing countries raised objections against the inequitable and contradictory nature of free access to PGR. The undertaking was thus clarified through various annexes stating that free access does not imply free of charge. Also, broad reference was made to farmers' rights and the compatibility of the undertaking with the concept of sovereign rights over plant genetic resources was recognized. During the pre-CBD period, systematic explorations were conducted globally, and samples of wild relatives, landraces and farmers' varieties were collected by scientists of the developed countries without any reciprocal benefit sharing or technology transfer arrangements. Many of these samples were conserved in the national and international gene banks as ex situ collections. The recognition of the sovereign right of nations under CBD raised the two outstanding issues. I. Facilitated access to the ex situ collections held world over prior to the CBD, and 2. The realization of farmers' rights enshrined in the revised agreed interpretation of the IGNOU. Resolution 3 of the final act to the CBD referred these outstanding issues to be dealt with by the FAO's global system on plant genetic resources, of which the international undertaking was the cornerstone. In November 1993, the FAO initiated the adaptation of the IGNOU in harmony with the CBD. In 1994, 12 centers of the Consultative Group on International Agricultural Research and subsequently other institutions signed agreements with FAO, placing most of their collections, some 500,000 accessions, in the international network. Through these agreements, the centers accepted a number of responsibilities and obligations, in particular, to hold designated germplasm in trust for the benefit of the international community, and not to claim ownership or seek intellectual property rights over the designated germplasm and related information. After considering the negotiating texts in a series of sessions between 1994 and 1997, a simplified draft text concentrating on scope, availability of plant genetic resources and farmers' rights was prepared. After sustained negotiations, the International Treaty on Plant Genetic Resources for Food and Agriculture (LTPGRFA) was adopted on 3 November 2001. 3.4.2 International Treaty, 0 Plant Genetic Resources for Food and Agriculture. The IGNOU provides a legal framework that not only recognizes the need for plant genetic resource conservation, sustainable agriculture and food security. But also defines a regime for ABS linking it with IPRs, Box 2. It provides broad guidelines but entrusts the responsibility for realizing farmers' rights to member states. The specific obligations include the need to keep an inventory of PGRFA, promote their collection, promote farmers and local communities' efforts to manage and conserve on-farm their PGRFA, promote in situ conservation of wild crop relatives and wild plants for food production, and cooperate to promote the development of an efficient and sustainable system of ex situ conservation. In exercise of sovereign rights of nations over their PGRFA, the treaty provides for a multilateral system, MS, covering a list of 35 food crops group of crops and 29 forage crops group of crops, provided as Annexure 1 of the Pgdipr. Selected on the criteria of food security and interdependence. The facilitated access to PGRFA shall be provided in pursuance of Standard Material Transfer Agreement, SMTA, adopted on 16 June 2006 by the governing body of Pgdipr in their first meeting held at Madrid, Spain. The SMTA has 9 articles, including rights and obligations of the provider and the recipient under Articles 5 and 6 and contains the provisions of Articles 12 and 13 and other relevant provisions of Pgdipr as referred to in the Box 2. The conditions of SMTA shall apply to the transfer of PGRFA among the contracting parties and also to another person or entity, as well as to any subsequent transfers of thus PGRFA. The Pgdipr includes groundbreaking, innovative provisions for monetary benefit sharing as reflected in the SMTA. If a product that incorporates material from the MS is commercialized in such a way that is not available without restriction to others for further research and breeding, a mandatory payment of 1.1% of the sales of the products less 30% or alternatively at 0.5% of the sales of any products and of sales of other products that are PGRFA belonging to the same crop, into the mechanism established for this purpose. However, payment shall be voluntary if products are available without restriction for further research and breeding. Box 2. Important provisions under Pgdipr related to conservation, access and benefit sharing. Farmers' rights, Article 9. Times to save, use, exchange and sell farm-saved seed propagating material. Times protection of their traditional knowledge relevant to PGRs. Times right to equitably participate in sharing benefits arising from the utilization of PGRs. Times right to participate in making decisions on matters related to conservation and sustainable use of PGRs. Establishment of Multilateral System, MLS, Article 10. Times recognizes sovereign rights of states over their PGRFA. Times authority to determine access rests with states and is subject to national legislation. Coverage of MLS, Article H. Times list of 35 crops genipools and forages, Annex I. Times PGRFA under the management and control of the contracting parties and in the public domain. Includes Annex I genetic resources held by CGIA and other international institutions. Times other holders of Annex I PGRFA, e.g. private sector, invited to include these in MLS. Guidelines for facilitated access to PGRFA, Article 12. Times solely for the purpose of utilization and conservation for research, breeding and training for food and agriculture. Times accorded expeditiously, with a minimal or no charge at all. Times all available non-confidential descriptive information shall be made available. Times no IPR or other rights so as to limit access shall be claimed over the PGRs or their genetic parts or components in the form received from the multilateral system. Times access to PGRs protected by IPR shall be consistent with international and national arrangements. Times PGRs accessed under the multilateral system shall continue to be made available. Times access to PGRs in situ conditions shall be provided subject to national legislation. Benefit Sharing Mechanism, Article 13. Times establish a global information system to facilitate exchange of information. Times facilitated access to technologies for the conservation, characterization, evaluation and use of PGRFA, subject to applicable IPRs. Times technologies protected by IPRs particularly for use in conservation as well as for the benefit of farmers in developing countries should be transferred under fair and most favorable terms. Times establishing strengthening developing scientific and technical education and training, facilities for conservation and sustainable use of PGRs and carry out scientific research in the developing countries. Times Standard Material Transfer Agreement for facilitated access to include a requirement that an equitable share of the benefits arising from the commercialization of product that incorporates material accessed through the multilateral system will have to be paid to the trust account set up under the treaty. Times the benefits that arise under the benefit sharing arrangements must be primarily directed to farmers who conserve and sustainably use PGRFA. 3.5 Biosafety issues. Biotechnology has opened up multitude of opportunities for the scientists to alter the genetic structure of any organism, thereby developing a number of genetically modified organisms and products from them. Notwithstanding the potential of biotechnology, the ecologists and environmentalists perceive the biosafety implications of the field release of transgenic crops among the major ecological risks. They apprehend that large-scale adoption of transgenics may lead to monoculture and may lead to genetic erosion and genetic vulnerability to insect pests and diseases in the genetic diversity over a period of time. Further, the possible transfer of genes from herbicide-resistant transgenic crops to wild or weedy relatives may occur and create superweeds. It may also lead to development of strains of insect pests resistant to the genes of known sources of resistance. And genetic recombination may also lead to emergence of new virulent strains of virus, especially in transgenic plants engineered for viral resistance derived from viral genome. The possible environmental impact of any transgenic crop will vary depending on the crop's reproductive behavior, the ecological system in which it is grown, its management strategy and the regulatory mechanism. 3.5.1 The Cartagena Protocol. Recognizing the potential risk arising from genetically modified organisms. GMOs, the CBD, in Article 19.3 provided for the parties to consider the need for and modalities of a protocol to ensure safe transfer, handling and use of GMOs in the second meeting of Conference of Parties, COP, in November 1995 an open-ended ad hoc working group to develop a protocol on biosafety through a negotiation process focusing on transboundary movement of LMOs was established. 6 meetings of the Biosafety Working Group were held from June 1996 to February 1999. The 6th and the final meeting of the working group was followed by the extraordinary meeting of the COP held in Cartagena, Colombia in February 1999 for adopting the protocol after sustained negotiations. The Cartagena Protocol on Biosafety was adopted in Montreal, Canada on 29 June 2000 and entered into force on 11 September 2003. Later, the Nagoya Kuala Lumpur Supplementary Protocol on Liability and Redress to the Cartagena Protocol was adopted on 15 October 2010 in Nagoya, Japan. India signed the Biosafety Protocol on 23 January 2001 and ratified the same on 5 September 2002. The protocol is a legally binding instrument governing transfer of GMOs from one nation to another. It deals primarily with GMOs that are to be intentionally introduced into the environment, such as seeds, trees or fish, and with genetically modified farm commodities, such as corn and grain used for food, animal feed, or processing. The objective of the protocol is to contribute to adequate level of protection in the field of safe transfer, handling and use of GMOs resulting from modern biotechnology that may have adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health and specifically focusing on transboundary movements, Article 1 of the Protocol, SCBD 2000. The protocol advocates adoption of the precautionary principle of the Rio Declaration on Environment and Development, which is a moral and political principle indicating that lack of scientific certainty is no reason to postpone action to avoid potentially serious or irreversible harm. 16. The environment and the onus of proof falls on those who would advocate taking the action. An important feature of the protocol is the procedure of Advance Informed Agreement, ALA, that applies to the first intentional transboundary movement of GMOs for intentional introduction into the environment of the party of import. It obliges the exporter to notify the competent national authority of the importing country and provide the necessary information such as modification introduced, the technique used and the resulting characteristics of the GMO, the regulatory status of the GMO in the country of export or any other details if required by the importing country to enable it to decide in favor of or against importing. This shall provide importing countries both the opportunity and the capacity to assess risks that may be associated with the GMO before agreeing to its import. 3.6 National Response. 3.6.1 Biological Diversity Act, 2002. The Government of Landia ratified the CBD on 18 February 1994. This required a national legislation for the sustainable management and conservation of Landia's natural resources. Accordingly, the Biological Diversity Act, 2002, BD Act, was formulated after intensive consultation with various stakeholders. The Act aims to ensure conservation and sustainable use biological diversity and to regulate access to biological resources of the country with the purpose of securing equitable share in benefits arising out of the use of biological resources and associated knowledge. The important provisions of the Act are given in Box 3. Box 3. Important regulatory provisions of the Biological Diversity Act, 2002. Section 3.1. No person referred to in subsection 2 shall without previous approval of the National Biodiversity Authority obtain any biological resource occurring in India or knowledge associated thereto for research or for commercial utilization or for biosurvey and bioutilization. 2. The persons who shall be required to take the approval of the National Biodiversity Authority under subsection 1 are the following, namely: A. A person who is not a citizen of India. B. A citizen of India who is a non-resident as defined in Clause 30 of Section 2 of the Income Tax Act, 1961. C. A body corporate, association or organization not incorporated or registered in India, or 2. Incorporated or registered in India under any law for the time being in force which has any non-Indian participation in its share capital or management. Results of research not to be transferred to certain persons without approval of National Biodiversity Authority.
Section 4. No person shall without the previous approval of the National Biodiversity Authority transfer the results of any research relating to any biological resources occurring or obtained from India for monetary consideration or otherwise to any person who is not a citizen of India or a body corporate or organization which is not registered or incorporated in India or which has any non-Indian participation in its share capital or management. Explanation: for the purposes of this section, Transfer does not include publication of research papers or dissemination of knowledge in any seminar or workshop, if such publication is as per the guidelines issued by the central government. Sections 3 and 4 not to apply to certain collaborative research projects. Section 5. 1. The provision of sections 3 and 4 shall not apply to collaborative research projects involving transfer or exchange of biological resources or information relating thereto between institutions, including government-sponsored institutions of India and such institutions in other countries, if such collaborative research projects satisfy the conditions specified in subsection 3. 2. All collaborative research projects, other than those referred to in subsection 1, which are based on agreements concluded before the commencement of this Act and in force. 7 shall, to the extent the provisions of agreement are inconsistent with the provisions of this Act or any guidelines issued under Clause A of subsection 3, be void. 3. For the purposes of subsection 1, collaborative research projects shall a. conform to the policy guidelines issued by the central government in this behalf, b. be approved by the central government. Section 6. 1. No person shall apply for any intellectual property right by whatever name called in or outside India for any invention based on any research or information on a biological resource obtained from India without obtaining the previous approval of the National Biodiversity Authority before making such application. A. Provided that if a person applies for a patent, permission of the National Biodiversity Authority may be obtained after the acceptance of the patent but before the sealing of the patent by the patent authority concerned. B. Provided further that the National Biodiversity Authority shall dispose of the application for permission made to it within a period of 90 days from the date of receipt thereof. 2. The National Biodiversity Authority may, while granting the approval under this section, impose benefit sharing fee or royalty or both, or impose conditions including the sharing of financial benefits arising out of the commercial utilization of such rights. 3. The provisions of this section shall not apply to any person making an application for any rights under any law relating to protection of plant varieties enacted by Parliament. 4. Where any right is granted under law referred to in subsection 3, the concerned authority granting such right shall endorse a copy of such document granting the right to the National Biodiversity Authority. Section 7. No person who is a citizen of India or a body corporate, association, or organization which is registered in India shall obtain any biological resource for commercial utilization or biosurveying, bio-utilization except after giving prior intimation to the State Biodiversity Board concerned. A. Provided that the provisions of this section shall not apply to the local people and communities of the area, including growers and cultivators of biodiversity, and Veds and Hakims, who have been practicing indigenous medicine. Some of the important definitions related to access, utilization and benefit sharing in the Act are given below. Benefit claimers means the conservers of biological resources, their byproducts, creators and holders of knowledge and information relating to the use of such biological resources, innovations and practices associated with such use and application. Biological resources means plants, animals and microorganisms or parts thereof, their genetic material and byproducts, excluding value added products with actual or potential use or value but does not include human genetic material. Biosurvey and Blue-Util-Satlong means severe collection of species, subspecies, genes, components and extracts of biological resource for any purpose and includes characterization, inventorization and bioassay. Commercial utilization means end uses of biological resources for commercial utilization such as drugs, industrial enzymes, food flavors, fragrance, cosmetics, emulsifiers, oleoresins, colors, extracts and genes. Used for improving crops and livestock through genetic intervention, but does not include conventional breeding or traditional practices in use in any agriculture, horticulture, poultry, dairy farming, animal husbandry or beekeeping. Fair and equitable benefit sharing means sharing of benefits as determined by the National Biodiversity Authority under Section 21. Value-added products means products which may contain portions or extracts of plants and animals in unrecognizable and physically inseparable form. A. Institutional mechanism. The Act has created a three-tier institutional mechanism comprising National Biodiversity Authority, State Biodiversity Boards and Biodiversity Management Committees. I. National Biodiversity Authority, NFJA. The National Biodiversity Authority was established under subsection 1(4) of Section 8 of the Biological Diversity Act, 2002, by Government of India in October 2003 at Chennai, Tamil Nadu. The authority comprises a chairperson, 10 ex officio and non-official members. The NBA has been charged with the overall responsibility of implementing the Act and regulates the requests for access to bioresources and associated traditional knowledge in partnership with the state biodiversity boards and the biodiversity management committees. At the local level, as per the Act, NBA shall perform the following functions. 1. Regulate activities referred to in sections 3, 4 and 6 and by regulations. Issue guidelines for access to biological resources and for fair and equitable benefit sharing. 2. Grant approval to foreigners, non-resident Indians and foreign companies for obtaining any biological resource, Section 3. For transferring the results of any research, Section 4. For seeking IPR rights on biological resources and associated traditional knowledge obtained from India, Section 6. 3. Develop and issue guidelines for facilitating access to biological resources and for fair and equitable benefit sharing under Section 21. 4. Advise the central government on matters relating to the conservation of biodiversity, sustainable use of its components and equitable sharing of benefits arising out of the utilization of biological resources, including notifications of threatened species, Section 38, designating institutions as repositories for different categories of biological resources, Section 39, and exempt certain biological resources, normally traded as commodities. Section 45, advise the state governments in the selection of areas of biodiversity importance to be notified under Section 37, 1, as heritage sites and measures for the management of such heritage sites. 6. Grant approval to certain persons seeking transfer of already accessed biological resource, associated traditional knowledge as per Section 20. 7. To determine and impose terms of equitable benefit sharing, arising out of the use of accessed biological resources and associated traditional knowledge. Section 21. 8. To take any necessary action on behalf of the Government of India to oppose the grant of IPR in any country outside India on any biological resource obtained from India or knowledge associated with such biological resource, which is derived from India. E. State Biodiversity Boards, SBB. The Act requires under Section 22, 2, that the state biodiversity boards are to be established. Accordingly, so far 25 states have established the SBBs. The SSBs deal with all matters relating to access to bioresources by Indians for commercial purposes. It has the authority to restrict any activity which violates the objectives of conservation, sustainable use and equitable sharing of benefits. E. Biodiversity Management Committees, BMCs. Under Section 41, the Act requires institutions of local self-government to set up biodiversity management committees in their respective areas. The mandate of the BMCs is conservation, sustainable use, documentation of biodiversity, and chronicling of knowledge relating to biodiversity. The task of setting up of BMCs remains a challenge, although some states have gone ahead notably in this direction and 31,542 BMCs have already been constituted. The provision of mandatory consultation of BMCs by the NBA and SBBs would ensure formalization of PLC by the communities and active involvement of the local and traditional communities in all decision-making processes related to biological diversity and traditional knowledge. The main function of BMC is to prepare People's Biodiversity Registers, PBR, in consultation with the local people. The register shall contain comprehensive Information on availability and knowledge of local biological resources or any other traditional knowledge associated with them. Establishment of comprehensive PBRs would not only help to inventorize and document the local biological and genetic resources, but also to conserve and sustainably use the biocultural diversity for rewarding income generation. B. Regulating access to biological resources and associated knowledge. The important provisions related to the regulations for access to biological resources and traditional knowledge are given in Box 3. The Act accordingly stipulates norms for access and differentiates the applicants in two categories. I. Persons who are citizens of India. Access to bioresources for research is unrestricted and free. However, Section 7 states that no person who is a citizen of India or a body corporate, association or organization which is registered in India shall obtain any biological resource for commercial utilization or biosurvey and bioutilization for commercial use except after giving prior intimation to the concerned state biodiversity board and adhering to its directives. E. Persons who are not citizens of India, non-resident Indians and body, corporate, association or organization not incorporated are registered in India or in tilde operated are registered in India but having any non-Indian participation in its share capital or management. Prior approval of NBA is required by the applicants of the second category, non-Indians, to access India's bioresources and associated TK for research and commercial use or engaging in biosurvey and bioutilization activities. Section 3 read with Section 19. They are also required to seek prior approval of the NBA for transferring research results abroad. Section 4. For applying for IPR. Section 6. And also for third-party transfer of the granted approval. Section 20. C. Exemptions under the Act. The following exemptions have been provided under the BD Act to promote bona fide use of bioresources for research and non-commercial use. Under Section 5 of the BD Act, Section 3, Access to Bioresource, and Section 4, Transfer of Research Results, shall not apply to the approved collaborative research projects. Guidelines on collaborative research projects involving transfer or exchange of biological resources or information relating thereto between institutions, including government-sponsored institutions, of India and such institutions in other countries, have been issued by the Ministry of Environment and Forests, MOEF, vide its notification dated 8 November 2006. Provision of Section 6 shall not apply to any person making an application for any right under the Protection of Plant Varieties and Farmers' Rights Act 2001. Where any right is granted under this law, the concerned authority granting such right shall endorse a copy of such document granting the right to the NBA. Provisions of Section 7, prior intimation to SBB for commercial use, shall not apply to local people and communities including village healers, Veds, farmers and other traditional growers, and also to Indian users of these bioresources for research. Normally traded commodities, 190 bioresources as notified by the MOEF. Vide its notification dated the 26th of October 2009, subject to the clarification issued on the 16th of February 2010, would be exempted from purview of this Act, provided they are traded as commodities. D. Criteria for benefit sharing. The Act, according to Section 21(1), insists that the NBA, while granting approvals, ensure, inter alia, equitable sharing of benefits arising out of the use of accessed biological resources, thereby products, innovations and practices associated with their use and applications and knowledge relating thereto in accordance with mutually agreed terms and conditions between the person applying for such approval, local bodies concerned and the benefit claimers. The NBA is yet to develop and notify guidelines for imposing terms for fair and equitable benefit sharing. Presently, the NBA has constituted an expert committee on ABS which has developed working guidelines and recommendations regarding benefit sharing on a case-by-case basis. The benefit sharing can be given effect in all or any of the following manners. A. Grant of joint ownership of intellectual property rights to the NBA, or where Benefit claimers are identified to such benefit claimers. B. Transfer of technology. C. Location of production, research and development units in such areas which will C. Facilitate better living standards to the benefit claimers. D. Association of Indian scientists, benefit claimers and the local people with research and development in biological resources and biosurvey and bioutilization. A. Setting up of venture capital fund for aiding the cause of benefit claimers. F. Payment of monetary compensation and other non-monetary benefits to the benefit claimers as the NBA may deem fit. Every determination of benefit sharing or order made by the NBA or ASBB under this Act or the order made by the High Court in any appeal against any determination or order of the by the NBA or ASBB shall, on a certificate issued by any officer of the NBA or ASBB or the Registrar of the High Court, as the case may be deemed to be decree of the civil court and shall be executed in the same manner as a decree of that court. A. Designated National Repository. As per the provision of Section 39, the central government may, in consultation with the NBA, designate institutions as repositories under this Act for different categories of biological resources. The repositories shall keep in safe custody the biological material including voucher specimens deposited with them. Any new taxon discovered shall be notified to the repositories or any institution designated for this purpose and deposit the voucher specimens with such repository or institution. The DNR consists of service providers and repositories of preserved specimen consisting of all fauna, herbarium, dried plant material. For research, the living cells, genomes of organism, and information relating to heredity and the functions of biological systems. DNRs also contain collections of culturable organisms, e.g. microorganisms, plant, animal and human cells, replicable parts of these, e.g. genomes, plasmids, viruses, cDNAs, viable but not yet culturable organisms, cells and tissues, as well as databases containing molecular, physiological and structural information relevant to these collections, and related bioinformatics. The NBA has prepared guidelines on DNR and it is in the process of notification. J. Restrictions for access to biological resources. Under Rule 16, the Act imposes certain restrictions on NBA's approval on requests related to access to biological resources and traditional knowledge if the request is on I. Endangered taxa, E. Endemic and rare species, E. Likely adverse effects on the livelihood of the local people, IV. Adverse environmental impact which may be difficult to control and mitigate, V. Cause genetic erosion or adversely affect ecosystem function, V. Purpose contrary to national interests and other related international agreements to which India is party, G. Revocation of access or approval. Revocation of access or approval granted to an applicant will be done only on the basis of any complaint or suo motu under the following conditions. I. Violation of the provisions of the Act or conditions on which the approval was granted, E. Non-compliance of the terms of the agreement, E. Failure to comply with any of the conditions of access granted, IV. On account of overriding public interest or for protection of environment and conservation of biodiversity. Rule 15, Sub-Rule 1. After having withdrawn the access permit, the authority is required to send an order of revocation to the concerned BMC and the SBB for prohibiting the access and to assess the damage, if any, caused and steps to recover the damages. H. Biodiversity funds. The BD Act provides for setting up of biodiversity funds at national, state and local levels. National Biodiversity Fund, the amount realized by the NBA through grants and loans, fees, royalties and other sources shall be credited to the National Biodiversity Fund, which is used for the following purposes: channeling benefits to the benefit claimers, helping the conservers and developers of biological resources, local communities in support of their on-location efforts towards conservation and sustainable use, conservation of biological resources and development of areas from where such biological resources or knowledge associated thereto has been accessed, socio-economic development of the areas in consultation with the local bodies concerned, State Biodiversity Fund, the amount realized by the SBB through grants and loans made to SBB or made by NBA, or from such other sources as may be decided upon by the state government, shall be credited to the State Biodiversity Fund. The State Biodiversity Fund shall be used for the management and conservation of heritage sites, compensating or rehabilitating any section of the people economically affected by restriction imposed under Section 37, conservation of biological resources, socio-economic development of areas from where such biological resources or knowledge associated thereto has been accessed subject to any approval granted under Section 24, in consultation with the local bodies concerned. Local Biodiversity Fund, the grants and 10A11s made by the state government, NBA, SBB or amount received by BMC as fees or other sources shall be credited thereto the local biodiversity fund at every area notified by the state government where any institution of self-government is functioning. The fund shall be applied for conservation of biodiversity in the areas falling within the jurisdiction of the concerned local body and for the benefit of the community, in so far such use is consistent with conservation of biodiversity. Penalties. The offences under this Act are cognizable and non-bailable. Contravention, or attempts to contravention or abetting the contravention of the provisions of Section 3, Section 4, or Section 6 shall be punishable with imprisonment for a term extendable to 5 years, or with fine extendable to 10 lakh rupees. In case where the damage caused exceeds 10 lakhs, such fine may be commensurate with the damage caused, or with both contravention or attempts to contravention, or abetting the contravention of the provisions of Section 7 or any order made under Section 24, 1, shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which may extend to 5 lakh rupees, or with both, if a person contravenes any direction given or order made by the central government, the state government, the NBA or the SBB for which no punishment has been separately provided under this Act, he shall be punished with a fine which may extend to 1 lakh rupees, and in case of a second or subsequent offence, with fine which may extend to 2 lakh rupees, and in the case of continuous contravention, with additional fine which may extend to 2 lakh rupees every day during which the default continues. 3.6.2 Protection of Plant Varieties and Farmers' Rights Act. The Protection of Plant Varieties and Farmers' Rights, PPVFR, Act, 2001 of India, PPVFR, deals with the protection of plant breeders' rights over the new varieties developed as per the requirement of TRIPS, while the Biological Diversity Act legislated in response to CBD. In order to incorporate the concerns of CBD, particularly on equitable benefit sharing, efforts have been made to harmonize both the legislations. Section 6(3) of the Biological Diversity Act requires prior approval of NBA before applying any IPR for any invention based on any research or information on a biological resource obtained from India. This provides NBA the opportunity to realize equitable sharing of benefits arising out of the use of biological resources and knowledge. However, an exemption has been provided for applicants seeking protection of varieties under the PPVFRA, as this legislation also has a provision for benefit sharing, only that the authority under the PPVFRA legislation is required to endorse a copy of the right granted under this Act to the NBA. Keeping in line with the spirit of the CBD provisions, the PPVFR Act also provides for protection of farmers' varieties and creation of National Gene Fund for promoting conservation of local varieties. 3.6.3 Patent Act. Section 6(1) of the BD Act links to the requirement under Section 10(4) of the Patents Amendment Act 2002 that requires mandatory disclosure in patent applications the source and geographical origin of biological material and traditional knowledge used in invention. It also provides for pre- and post-grant opposition of applications and revocation of granted patents on grounds of non-disclosure or wrongful disclosure. A sample of the bioresource is also required to be deposited in the designated national repository. 3.6.4 The Biosafety Regulatory Framework. Genetically modified organisms are regulated in India under the purview of the Indian Environment Protection Act 1986. The broad definition of environmental pollutant was used by the Ministry of Environment and Forests in 1989 to issue rules to govern use of genetically engineered organisms under the APE Act. The 1989 inches rules for the manufacture, use, import, export and storage of hazardous microorganisms, genetically engineered organisms or cells. Henceforth 1989 rules provide the legal framework for regulation of GMOs. In India, since the 1989 rules call for guidelines to be developed to give them effect, biosafety guidelines were issued by the Department of Biotechnology under the Ministry of Science and Technology. These rules are notified with the purpose of protecting the environment, nature and health from the application of gene technology and microorganisms. These rules cover industries, hospitals, research institutions and other establishments that handle microorganisms or are engaged in genetic engineering. The application of these rules extends not only to the genetically engineered organisms, etc., but also to any substance, products, and foodstuffs containing such cell organisms or tissues. More specifically, the rules cover storage and handling of hazardous organisms. As per these rules, Review Committee on Genetic Manipulation, RCGM, established under the Department of Biotechnology supervises research activities including small-scale field trials. Approvals for large-scale releases and commercialization of GMOs are given by the Genetic Engineering Approval Committee, GEAC. In addition to these two committees under the Government of India, the 1989 rules provide for establishing the state biotechnology coordination committees and district-level committees for monitoring. The rules also mandate that every institution engaged in GMO research establish an institutional biosafety committee to oversee such research. 3.7 Summary. The Convention on Biological Diversity, CBD, and the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, have led to new dimensions of statutory provisions and regulatory obligations for access and utilization of genetic resources. The CBD entered into force on the 29th of December 1993 and affirmed the sovereign rights of nations over their biological resources. The main objectives are I. Conservation of biological diversity, E. Sustainable use of its components, and E. Fair and equitable sharing of the benefits arising from the use of genetic resources. In this regard, the CBD incorporates two obligations, namely, for providing access on mutually agreed terms, MAT, and prior informed consent, PLC. Implementation of the CBD is a dynamic process and the Conference of the Parties, COP, is the governing body of the convention that takes decisions on outstanding issues. To facilitate implementation of CBD obligations with respect to access and benefit sharing, several initiatives including the Bonn guidelines were taken, culminating in adoption of the Nagoya Protocol M. Access to genetic resources and the fair and equitable sharing of benefits arising from their utilization on the 29th of October 2010. The CBD provisions encompass all biological resources, however, the plant genetic resources for food and agriculture, PGRFA, received special attention. The negotiations on two outstanding issues, I. The facilitated access to the ex situ collections held prior to CBD and E. The realization of farmers' rights, culminated with the adoption of the International Treaty on Plant Genetic Resources for Food and Agriculture, ITPGRFA, on the 3rd of November 2001. The treaty provides for a multilateral system, MS, for facilitated access to PGRFA covering a list of 35 food crops, group of crops and 29 forage crops, group of crops in pursuance of Standard Material Transfer Agreement, SMTA, which includes provisions for monetary benefit sharing. The Cartagena Protocol on Biosafety was adopted on June 29, 2000. Recognizing the potential risk arising from genetically modified organisms, GMOs, and entered into force on September 11, 2003. Later, the Nagoya Kuala Lumpur Supplementary Protocol on Liability and Redress to the Cartagena Protocol was adopted on as October 2010. The Protocol Gov.RNS. Transfer of GMOs to ensure adequate level of protection in the field of safe transfer, handling and use of GMOs against any adverse effects on conservation and sustainable use of biological diversity, specifically focusing on transboundary movements. In India, the Biological Diversity Act 2002 came in force since April as 2003. The Act regulates access to genetic resources and associated knowledge, and equitable sharing of benefits arising out of their use. To achieve this, it establishes the National Biodiversity Authority, NBA, the State Biodiversity Boards, SBB, and the Biodiversity Management Committee, BMC. Further, the PPVFR Act provides for protection of farmers' varieties and creation of National Gene Fund for promoting conservation of local varieties. The Patents Amendment Act 2002 requires mandatory disclosure in patent application of the source and geographical origin of biological material and traditional knowledge used in invention and deposition of a sample of the bioresource in the designated national repository. Genetically modified organisms are regulated in India under the purview of the Indian Environment Protection Act 1986. Thank you for listening. We will be back with the next chapter.